So hi, my name is Guilherme Leal. I am a lawyer. I work with environmental law, as well as environmental issues related to oil and gas exploitation. I'd like to thank Hugo for his presentation, which was very enlightening. I learned a lot. And I would like to thank Professor Romulo for the invitation. I'm very happy to be here, not only because I'm at FGV, where Romulo was kind enough to give me a little room to develop some work with the FGV students, together with Antonio Augusto. And I'm very happy to be here as well because this is an event with George Washington University, where I spent a lovely year doing my master's degree. So, Lee Paddock, Professor Lee Paddock, hi. I'm going to talk here about some issues, legal issues related to environmental liabilities. Talking about civil liability, administrative liability, and criminal liability. We're gonna deal here not only with impacts caused by shale gas exploitation, but also and mainly by oil and gas exploitation upstream or offshore. And this is sadly a reality that we face in Brazil and in the whole world. This kind of activity involves risks, and these risks surely will lead to an incident, and this incident gives rise to liability. When this incident occurs, either by an unfortunate event or by reckless development and operation, this activity has a great potential of great consequences, not only for the environment, but also for society as a whole. And because of these great consequences, a lot of players turn their head to this event. And in Brazil, we have a lot of players. We have a lot of parties. We have the public prosecutor, the federal and state public prosecutor, who have standing to pursue compensation for environmental damages. We have the Federal Environmental Agency, IBAMA, which is the Brazilian EPA. We have ICMBio, which is the federal agency responsible for controlling protected areas. We have state environmental agency. Here in Rio is called INEA. We have municipal environmental agencies. We have ANP, the port authority, the police, congressmen, governors, and public authorities, NGOs, Greenpeace, and other like. We have impacts on society, on communities, on fishermen communities. Individuals who are also impacted individually. Cultural Heritage Agency, here in Brazil called IFAM. They all turn their head to this kind of incident. They are all concerned, and they are legitimate concerned with this incident. Each part concerned with specific aspects of this incident. And can this get worse? I mean, for the company who already has to deal with all these parties? Yes. When they all transmitted in the television. When this occurs, the incident gets a higher proportion and becomes even, it is serious, but it becomes more serious. And this kind of phenomenon is in a way very good for the development of the oil and gas policy and regulation. And we have an example. In 2000, there was a great incident in the Guanabara Bay here in Rio de Janeiro. The Guanabara Bay, for those who do not know this place, is one of the postal cards of Rio de Janeiro. It's perhaps one of the most beautiful places that we have in our city. In 2000, this postcard, this heritage that we have, which inspired a lot of musicians in Rio, faced a disaster. We had an incident, an oil incident in the Guanabara Bay, which caused horrible pollution affecting not only the sea, the coast area, but also social activities, the fishermen activities, and had a great repercussion. And this image here of this bird covered with oil gained so repercussion that this issue became very sensitive, and the population needed a response from the government. And the government gave an answer. In 2000, if we look at the main environmental statutes that we had at that time, we could highlight our constitution, our 1988 constitution, which established general principles of the environmental protection. Our NEPA, the 1981 NEPA, our National Environmental Protection Act, our Environmental Crimes Act from 1998, and a decree from 1999 addressing environmental infractions. But we did not have an act, a statute dealing specifically with oil pollution, with oil activities. And the answer of the government was the enactment of the law 9966, the 2000 Oil Act, we may call it. And in 2002, we have the decree that regulated this law. So basically, this is the basic legal framework, legal structure that regulates this activity. NEPA, Environmental Crimes Act, the Environmental Infractions Act, Oil Act, and the Oil Infractions Act. So these are the rules that we're going to talk here in this presentation. One of the major problems of this 2000 incident at the Guanabara Bay was the lack of proper response to the incident, lack of proper communication and interaction between the company and the agencies involved in the fiscalization and control of the activity. So with this Oil Act, very important instruments were implemented, which was the incident communication and the individual emergency plan. The Oil Act established that any incident occurring in organized ports, port installations, pipes, vessels, platforms, etc., that may cause pollution of the waters under national jurisdiction shall be reported immediately to environmental agency, port authority, and ANB, our regulatory agency. So any incident that may cause pollution. Okay, Guilherme, what is incident? Because all lawyers are concerned about definitions, legal definitions. So we need definitions, concepts. And the law answers this question. Incident, it's any discharge of a harmful or hazardous substance resulting from an intentional or accidental fact or action that causes potential risk, damage to environment or human health. And IBAMA has a rule, a normative instruction that lists these substances that are held to be harmful and hazardous. This definition has a tricky point. If you note, the concept of incident is the discharge of a harmful substance that may cause potential risk. And often we have these companies that question, but there was just a little spill, a few liters that do not cause any potential risk to the environment. Am I obliged to, do I have to report this to the agency or not? I would like to know afterwards your opinion about this aspect. But I'm not giving the answer here. But often the environmental agencies, they are concerned with not only with one sole and isolated spill, but they have to know a broader scenario. Because if you have a small spill one day, you may have another small spill next week, and if you sum all those incidents, you may have a serious consequence. So the potential risk here is very relative, and as a rule, any kind of spill should be reported to the relevant agencies. And who are those agencies? The law, as we saw, makes reference to three kinds of agencies. The environmental agencies, which in Brazil we have these three levels of environmental agencies: the federal, the state, and the local, the municipal. The Port Authority and ANB, the regulatory agency. I'm going to focus here only on the environmental agencies. And once we are facing a spill offshore, who should we contact? Who should we report the incident? As a rule, the federal agency is responsible for conducting the environmental permitting proceeding of any activity developed offshore. And because of that, the federal EPA is also responsible for controlling and inspecting all these activities developed in the territorial waters, the sea. So as a rule, the communication should be made to the federal agency. Okay, but sometimes we have different situations. Sometimes the oil sheen is moving towards the coast and may impact as well the life of fishermen activities, may impact the the life of a small city, and depending on the case, the state and the municipal agencies should also be reported because they have to be aware of the situation. So this may depend on the case. And when should this communication be made? The Oil Act says that this report should be made immediately. Okay, what is immediately? It's 1 minute after the incident, 1 hour after the incident, in the same day. As a rule, it would be in the same minute. Why? The Oil Infractions Act of 2002 describes an infraction of non-communication of incidents. This law sets forth that those who do not communicate the incident for the relevant authorities are subject to fine. A fine that may range from 7,000 reais to 1 million reais, plus 7,000 reais per hour as from the incident. So, for each hour that you do not report the incident, your fine may increase 7,000 reais. So, as a rule, this incident should be reported in the same moment. But of course, that we know that this is almost impossible to do because when an incident occurs, there are a huge effort to concentrate it in the event. So perhaps this 7,000 reais per hour would be too much. But this is just my opinion. And not only the non-communication of incident may be an administrative infraction, but also one may claim that this might be a crime. The 1998 Environmental Crimes Act established some infractions, some crimes that may be applied to this kind of situation. For instance, failure on part of those who have the legal or contractual duty to do so to fulfill any obligation of relevant environmental interest. This is a very broad article. And what is obligation of relevant environmental interest? To communicate an incident is this kind of obligation, might be. So it wouldn't be impossible. In fact, we see this in practice, that the public prosecutor used this provision as a cause of action for penal lawsuits, as well as obstructing inspection and to provide environmental report that is wholly or partially false or misleading. So these are all conducts that may be applied in this situation of non-communication of incident. And normally, the way to communicate the incident to the authorities is described in a document called Individual Emergency Plan. This document describes all the procedure that the company should should observe when responding to an incident. So, according to this Oil Act of 2000, it is an obligation to have an individual plan. Article 7 sets forth that in order to respond to pollution caused by oil and harmful substance, organized boards and installations and platforms shall have individual emergency plans. This plan is regulated by a resolution of our environmental council, or CONAMA, we call it, this council. And this regulation describes the minimum content and how this plan should be developed and approved by the environmental authority. The development of this plan is part of the environmental permitting proceeding of the activity. So it's part of the approval of the activity to approve the plan. And the lack of this plan may give rise to another infraction, which is also described in the Oil Infractions Act, which is to operate organized boards, platforms, etc., without individual emergency plan. And there is a daily fine for this kind of infraction, which may range from 7,000 to 70,000 reais. This also may be a crime. Why? Because normally to have and to implement the individual emergency plan is a condition of validity of the environmental permit. Every environmental permit has several conditions listed on it. One of this is to have and to implement the emergency plan. If the company fails to meet one of these conditions, if the company violates one of these conditions, this might be seen as a crime. So lack of individual emergency plan may be regarded as an environmental crime as well. This was a very brief comment on oil and gas response to incidents involving the exploration of these resources. And I'm going to talk here just for a few seconds about shale gas, because Hugo has already gave a great lecture on this issue. The point that I want to stress here is, yes, the world is with the eyes on the US due to this shale boom, as mentioned in this newspaper. And are we in Brazil ready to develop this kind of activity? We still have some lack of regulation, and especially, I'm saying especially as to environmental issues. We do have a law that addresses oil and gas, that lists several infractions related to this activity, but we still don't have regulatory and environmental rule concerning these aspects. And as you mentioned, there are several efforts from ANP to provide, to establish a landmark in this field, which is very good to hear. And the exploration of this activity, as you mentioned, involves several environmental concerns that may be air emission of methane or any other pollution, the great consumption of water that may may lead to some impacts in water resources, possible drinking water contamination, soil degradation and contamination, etc. So, given that we don't have a specific regulation on these environmental issues, and given the posture that our courts have on these kind of aspects of environmental issues, as well as environmental agencies, it is possible that the development of this activity be guided by the precautionary principle. So we are not sure about the actual results or consequences of this kind of activity. So we are going to establish very strict and severe conditions in order to operate and to minimize our risks, our environmental risks, our social risks. So I wouldn't be surprised if several decisions from, especially the environmental agency, if several decisions are based on the precautionary principle. And it's important to emphasize that if the company fails to meet those requirements, those strict and severe requirements, this company may be practicing a crime. Because according to our 1998 Environmental Crimes Act, not to undertake, when so required by the competent authority, precautionary measures in cases of risk of serious and irreversible environmental damages is crime. Maybe I'm wrong, but maybe the precautionary principle would be used to establish several conditions and several measures for the companies. And now we're going to talk about the liabilities that appear because of the incidents. Not only because of incidents related to oil and gas exploration offshore, but also on the exploration of shale gas onshore. We have a liability regime in Brazil that is not applied specifically to one sector. Environmental liability, especially civil liability, is a sole rule which is applied for any potential polluting activity in Brazil. So according to our constitution, the 1988 Constitution, we have a triple liability when it comes to environmental issues. According to our Constitution, conducts and activities considered harmful to the environment shall subject violators, either individuals or legal entities, to administrative and criminal sanctions, regardless of the obligation to repair the damage. So we have administrative, criminal, and civil obligation. In other words, one environmental damage, one incident gives rise to three kinds of liabilities: civil, administrative, and criminal. The main purpose of civil liability is to compensate damage of the victims, either individual victims or the society as a whole. It involves recovery of damages as well as indemnification, financial compensation of these victims. And who pursues this liability? Who seeks this liability is the public prosecutor, mainly the Ministério Público, who has standing to file civil actions against companies that cause pollution. The environmental agencies, IBAMA, ANP, IBAMA, our EPA, they also have standing to file civil actions. NGOs, they have standing, they have to have some specific characteristics in order to meet this requirement, but it is possible that NGOs file civil actions pursuing compensation for environmental damages, because in Brazil we have a law that that treats civil actions, that establish a vast array of persons that have standing to file this lawsuit. So a lot of players may file this, may pursue this liability. The administrative liability or administrative liability has the purpose of punishment and prevention. And who pursues this? Is environmental agencies, regulatory agencies, and port authorities. The environmental agencies, they have standing not only to file lawsuits, but also to issue administrative acts, such as embargoes, and apply fines, not in lawsuits, but within administrative proceeding, where the companies also have the right to defense. And also criminal liability, the main purpose of which is punishment. And who pursues this is the public prosecutor. The public prosecutor may not only file lawsuits, civil actions for the compensation of damages, but also criminal actions for the punishment of those responsible for the activities that gives rise to violations to the environmental rules. So this is the basic structure of environmental liability in Brazil. As to civil liability, again, if we see all those rules that we mentioned in the beginning, we're going to focus on this 1981 NEPA. This law has the basic regulation on civil liability, which in fact is very simple. We don't have many rules on this matter. We have 2 or 3 provisions that are applied in any case involving environmental damages, from oil and gas leakage and spill and incidents to a small store that had a problem with sewage. So according to this 1981 NEPA, one of its main objectives, its main goals, is to impose upon the polluter and the predator the obligation to recover and or identify the damage caused. According to the 1981 NEPA as well, and here is the main provision regarding civil liability. The polluter is obliged to, regardless of fault, identify for or repair the damages caused to the environment and to third parties affected by his activity. Every civil action makes reference to this provision. 99% of the actions concerning environmental damages make reference of this for this article. The 1% that does not mention this article is wrong. Yeah. So here we have the polluter-based principle recognized and acknowledged by our environmental policy. And as I mentioned, the polluter is obliged to recover the damage and indemnify the victims. Okay, but who is the polluter? This is a key question. The 1981 NEPA has the definition of pollutant, but as we will see, it doesn't help a lot. Why? Because the polluter is the natural, legal, public or private person directly or indirectly responsible for an activity that causes environmental degradation. So why it doesn't help a lot? Because what is directly and indirectly? Who is the direct polluter and who is the indirect polluter? The direct polluter, it's easier to define. Even common sense defines the notion of direct polluter. But who is the indirect polluter? How far this concept go? This is not easy to answer, and we're going to talk in a few minutes. We're going to talk about this. As we've seen, civil liability is applied regardless of fault, which means that civil liability, in order to impose liability to compensate damages, it is irrelevant to prove that the person acts with negligence or intent. You don't have to, the plaintiff doesn't have to prove negligence or intent, which is in Portuguese is culpa ou dolo. This is irrelevant. There are only three elements in order to have a civil liability case. It is a damage, it is a causal link, a causation between a damage and an act or an omission. So an activity that causes damage. But this activity is being carried out with environmental permits, and we use the best available technology. We were very careful during our operation. It doesn't matter. We just need an activity, a damage, and a link. That's all. So, one of the elements, the damage, the environmental damage. What is this, the concept of environmental damage? The NEPA doesn't have a concept of damage, of environmental damage, but there's a concept of pollution. And it's a very broad and far-reaching concept, as we will see, because it's the degradation of environmental quality resulting from activities that directly or indirectly, and here we see again a very broad notion of directly and indirectly, that jeopardize the health, safety, and welfare of the population, create adverse conditions for social and economic activities, adversely affect the biota, affect the aesthetic and sanitary conditions of the environment, and discharge materials or energy in violation of environmental standards. So we have a very objective concept, discharge above the standards. We have more subjective aspects, such as affect the aesthetic and sanitary conditions. We have a social concern with create adverse conditions for social activities. So this is a very broad concept. One may say that because it is too broad, it doesn't define anything. Again, the polluter is applied to identify damage caused to the environment and to third parties. So damages caused to the environment should be compensated, should be recovered. Those damages involve damages caused to natural resources such as water, air, flora, fauna, as well as third parties. Damages caused to, because of the damages caused to the environment, people have suffered losses and damages as well. Damages to health, to economy, to culture. And in light of these two kinds of damages, there is an obligation to repair damages to property, not only collective property, but also individual property. For instance, community of fishermen had to suspend the fishing activities, so they lost profits. So the company that gave cost this pollution should identify this property damage, this material damage.
What if together with an oil well, you have some acts of God, and then you have the pollution?
We'll get there. We'll get there. But not only material damages as well as moral damages, which is kind of pain and suffering. Because the fishermen community had to suspend their activities, they spent a lot of time very nervous and anxious about their future, about their family, about the resources, that how they're going to maintain their family. So this may give cause to moral damages, to pain and suffering. So this is also to be identified, to be compensated. And it's very common to, if we see our precedents, our judicial precedents, it's very common to see some elements that help in the definition of the amount of money or the kind of compensation that is and remediation that is implemented. For instance, for damages to property, we see a lot of precedents and a lot of decisions from our courts saying that it is important to analyze the extension of the damage, the loss of profit, in order to establish the amount and the measures that should be implemented. But this establishment should also consider preventive measures. Not only you have to pay for what you did, but you have to pay for not doing it again. And there is also an educative element. The court said that, okay, but you have to do some more so you don't do it again. And courts also take into consideration the economic power of the company, of the polluter. So it's a different case if you have a big oil company and if you have just a small person that unfortunately was involved in an accident. And moral damages. Courts is also taking into account economic power of the polluter, the educative element, and punitive damages. This may be one of the few exceptions of the strict liability regime that I mentioned before. Because as we see, the rule of environmental liability, of environmental civil liability, is strict liability. Fault, intent, and negligence is irrelevant. But in order to establish the amount of moral damages, courts take into account if you act properly, if you were reckless when you were operating, if you use care during the operation. So depending on how of the causes of the incident, the amount of moral damage may be higher or lower. Besides the damage, there must be an activity. On one hand, the damage and the activity, which doesn't have to be an unlawful or illegal activity. You may operate your activity according to the permit, but if because of an incident, of an accident, there has been a spill, it's the risk of the activity. So they have to to compensate the damage. And this is, has been already acknowledged by our court. And the Oil Act makes express reference of this, to this idea. The circumstances in which the discharge of harmful substances, in other words, is permitted, do not accept the obligation to repair the damage. So the Oil Act of 2000 recognized this rule. And the causation, which, as I mentioned, is a very far-reaching concept because it involves persons directly and indirectly involved in the cause of the environmental incident. And just to have a notion of how broad this concept is, there is a very known decision by our Justice Herman Benjamin, which is one of the leading voices in Brazil as to environmental law. According to his decision, it is considered a polluter whoever acts, whoever fails to act when one should have acted, whoever does not care when others act, whoever remains in silence when ought to denounce, whoever finances others' action, and whoever benefits when others act. This is free translation, but this is just to give an idea of how broad this concept may be. What is whoever does not care when others act? This is a very important concept and it's very subjective. So there's no objective definition of this figure. Civil liability in Brazil is not only strict, but also joint and several, which means that if there is more than one polluter, they are both liable for the damage. And the plaintiff may seek compensation through a lawsuit against just one of the polluters. And this one polluter is obliged to recover the full damage. This is also recognized by our Superior Court. And the other polluter may be charged by the one that had to recover all the costs related to environmental damages. And now answering your question, Luciano. In Brazil, civil liability for environmental damages is not only strict, regardless of fault, and not only joint and several, but also comprehensive or absolute. It's difficult to find a word to translate this risco integral. Is a risco integral doctrine. In free translation, may be comprehensive liability or absolute liability, which means that Brazilian courts do not admit defenses of the defendants based on third parties acts of court, or even the victim's assumption of the risk. So, if the company is developing a risky activity and gives cause to damage, even if this damage was caused not only by the activity, but also because an act of God, a storm that was impossible to foresee, that was unpredictable. Even in these cases, there is no defense. The plaintiffs only have to prove that was an activity, a risky activity, a damage, and the link.
But in the case of an act of God, there is no link
There's no link. Why?
between your action and the damage. If
Why?
it was an act of God.
Could be between a hurricane where there was several hurricanes.
I mean, I understand, but then there's no link in the theory.
But does the activity contribute to the damage? Because it existed. It was being developed. There was an operation. If there wasn't an operation, there wouldn't be a damage. There wouldn't be pollution. So who bears this risk? Is it the society, or is the company which is developing a risky activity and is making profit of it? So this is the basic idea behind the comprehensive risk. It's like an absolute risk. It's the full risk, which does not admit any kind of defense based on intervening causes. What kind of defense do you have? There's no causation between the activity and the damage. Okay, this is a line of defense. And there is no damage. The plaintiff is claiming environmental or any kind of damage, but I will prove here that there is no damage. So basically, these are the main defenses that the defendant has in civil liability cases. We're not dealing with administrative nor criminal liabilities. The comprehensive risk doctrine accepted by our Superior Court, and the burden of proof. When it comes to environmental civil liability, the burden of proof lays on the defendant's shoulders. The defendant has to prove that he or she did not give cause to the damage. If the plaintiff presents a scenario that is likely to be real, is likely to be true, the defendant has to prove that that is lie, that is wrong. There's no causation whatsoever between the activity and the damage, or there's no damage whatsoever. And the law also admits to the piercing of corporate veil, which means basically that, okay, as a rule, the company should be obliged to compensate and identify the damages, but I may seek this compensation not against the company, but against its directors or partners or shareholders. But our Superior Court has already accepted that this kind of rule, this kind of liability should be subsidiary. In other words, we should first go to the company, then we go, if the company does not have enough resources to compensate the damage, then we go to the shareholders or the directors, the partners. And the statute of limitation, which in Portuguese is prescrição, when it comes to civil liability for environmental damages, our court has already decided that there is no statute of limitation. So you may claim environmental compensation for an activity, for a damage that was caused 10, 15, 20, 30, 500 years ago, which may give rise to some discussion that we don't have enough time here. And to finish this part of civil liability, one important instrument that is often used by the parties involved in lawsuits is the TAC, this term of adjustment of conduct, or is an agreement. In the free translation, or simple, is an agreement where the public prosecutor or the public agency that filed the lawsuit have the opportunity or have the chance to settle with the company and or the defendant. So this is a very common instrument, and is an instrument that should be more used in Brazil. Civil liability, if you have any question, I'll answer in the end of the presentation. Now we'll talk about administrative or administrative liability. And we're going to focus here in two acts. The Environmental Infractions Act, which regulated the Environmental Crimes Act, and the Oil Infractions Act. Both acts, both statutes describe conducts that are deemed to be illegal infractions, and describe the penalties for those who fits the description. The Environmental Infractions Act, which deals specifically with environmental infractions like cause pollution, lack of permits, to cause damage to protected areas, to cause damage to water resources. These infractions in violation to environmental resources, they are addressed in this decree 6514. And only the environmental agencies have the power, have the police power to implement and to impose the penalties and sanctions described in this act. The other act, the Oil Infractions Act, describes not only infractions such as the discharge of oil, but also the lack of communication. And not limited to environmental infractions, but also infractions that are relevant for the regulatory agency as well. So there are some agencies that have standing and have the police power to implement this Oil Infractions Act, which are the environmental agencies, the Port Authority, and ANP. Just basically, the Oil Infraction Act has several descriptions of infractions, and each article which describes these infractions, each article mentions who is the authority responsible for implementing and imposing the penalties related to this article. So here is very clear in this act who is responsible for what. This decree, because was enacted by a federal government, because it was enacted by the president, as a rule, in theory, it should be only applied by the federal agency. Each state and each municipality should have their own regulation concerning environmental infractions, and they have to use their own regulation to impose the penalties and sanctions. This also may give rise to great debate, but we have just a few minutes. Just an example of what kind of penalties, administrative penalties we have, is warning, fines, daily fines, destruction of products, embargo, interruption of works, demolition, etc. And in one hand, we have a strict liability regime in the civil liability. This is not the rule in the administrative liability. Recently, our Superior Court differentiated the strict liability regime from the administrative liability regime, where fault is an essential element. This is a very recent decision. This was, and still is, a very delicate issue, because we have many decisions that apply administrative liability based on strict liability regime. In other words, based regardless of fault. And the ground of this decision is the rule concerning civil liability that I mentioned, the NEPA provision. So courts were applying NEPA provision for imposing administrative liability strictly, which was very questionable. And now this decision clarified this issue. Differently from civil liability, the conduct should be unlawful. In other words, it's not any kind of conduct. If the company operated according to the permit, there is a defense. But also in the administrative liability, the burden of proof lays on the shoulder of the defendant. Why? Because the penalty is imposed through is an act. It's an administrative act, and administrative acts that are imposed by public authorities have the presumption of validity. So what is written in that act is presumably true. So the defendant must prove that what is written in that act is not accurate. So this was already acknowledged by our courts. Just a few infractions as examples. To cause pollution of any kind at levels that result or may result in damage to human health, or cause the death of animals or significant destruction of flora. A fine that may reach 50 million reais. Other infractions that are also subject to this fine of 50 million reais. Air pollution, water pollution, to prevent the use of beaches, and the lack of environmental permit or environmental license, which is also an infraction, which may subject the the wrongdoer to a fine of 10 million reais. The Oil Infraction Act also established an important infraction, which is the discharge of oil. And it's important to highlight the main factors that lead the agency to establish the value of the fine, the amount of the fine. So when issuing a fine, they have to consider the gravity of the facts, the antecedents of the wrongdoer, and the economic situation of the wrongdoer as well. And here we don't have the same comprehensive liability regime that we have in civil liability doctrine. Here, our courts accept defenses based on intervening causes, such as act of God and third parties act. There must be proven a link between the activity caused by the activity developed by the wrongdoer, or potentially and supposedly wrongdoer, and the violation of the environmental law. And the statute of limitation for administrative infractions is 5 years. And to conclude our criminal liability regulation, we're going to address specifically this law, the Law 9605, the 1998 Environmental Crimes Act, which is unquestionably a fault-based liability, which is completely different from strict liability. So it is crucial to demonstrate intent or fault in order to impose criminal liability. The rule should be only those who intentionally practice crime should be convicted, and the exception should be crimes based on fault, on negligence. As with the administrative liability regime, we need to have an unlawful conduct, and just to pick up select some environmental crimes, also pollution is considered a crime according to the 1998 Environmental Crime Act. And lack of permit, lack of license is also considered a crime according to our regime. But here we don't have the presumption, we don't have the burden of proof on the defendant. According to our Constitution, no one shall be considered guilty before the issuing of a final and unappealable penal sentence. So the burden of proof here is not of the defendant, but the plaintiff, is the public prosecutor, which has the burden of proving that that person committed a crime. Our law, and we are 5 minutes to conclude, admits the criminal liability of legal entities of corporation, and it's Article 3, which is the legal entities or the corporation will be liable in the criminal spheres as provided in this Act in cases in which violation is committed by a decision of its legal or contractual representative or collegiate body, and in the interest or benefit of your corporation. So these are two basic elements that should be proven by the plaintiff in order to impose criminal liability. And liability to legal entities to corporation may be fine, restrictions of rights, and services to community. And liability of individuals is also addressed in our criminal law, and has a specific provision on that aspect, according to which whoever in any way contributes to the practice of a crime, provided is liable to the pertinent penalties to the extent of their fault, which means that they recognize here the fault-based liability, as well as the director, administrator, member of the board of a technical agency, auditor, manager, agent, representative of the corporate entity who is in full awareness of the criminal conduct of others and fails to prevent such practice when it was in his power to do so. So there is a specific provision addressing and regulating the criminal liability of individuals or individual persons as well. But it is important to highlight that it is crucial to establish a clear link between the person's conduct and the person's position in the company and the crime that was committed in order to implement and to impose criminal liability on those persons. Applicable penalties is fine and imprisonment, restrictions of right, and also there's criteria for the establishment of penalties, which as well as the administrative liability takes into account the gravity of the fact, antecedents, and the economic situation of the wrongdoer. Here we admit defenses based on intervening causes. In other words, the defense is based on act of God and third parties' action. And the statute of limitation depends on which infraction, which crime we are dealing with. That may range from 2 to 12 years according to our penal code. And that's, thank you very much.